Where's Washington? So I shall proceed accordingly with that ruling stroke judgment.
Yes, my lord. Please.
Escort, please.
This suit was commenced by way of an originating motion on 13th day of August 2025. Pursuant to Section 46, Sub 1 and 2, Constitution, Federal Republic of Nigeria, 1999 as amended. Section 254, Sub 1, Constitution, Federal Republic of Nigeria, 1999 as amended. Articles 15, 19, and 22 of African Charter on Human and People's Rights, Ratification and Enforcement Act, Cap 49, LFN 2004, Section 3, National Minimum Wage Amendment Act 2004, and under Fundamental Rights Enforcement Procedure Rules 2009, an inherent jurisdiction of this court. The suit is predicated upon the following grounds. Applicants were lawfully employed by the Sokoto state government through its Ministry of Health and have been performing their duties diligently and without misconduct. 2. Despite their active service, the respondents have deliberately and without lawful justification failed or refused to pay the applicant salaries and emoluments since the commencement of their employment. 3. The failure to pay salaries amounts to a violation of applicants' rights to human dignity, right to work, and protection from inhuman and degrading treatment as guaranteed under the Constitution and African Charter. 4. The respondent's conduct amounts to economic oppression, violates social justice, and is incompatible with the fundamental objectives and principles of state policy under the Constitution. The applicants have the constitutional right. 5. Applicants have the constitutional right to approach this honorable court for redress and enforcement of their fundamental rights. I believe, counsel, you are still with me?
Yes, my lord.
All right, thank you.
Yes, ma'am.
Thank you. The applicants are consequently seeking for the following reliefs. A declaration that the refusal, failure, or neglect of the respondents to pay the salaries and entitlements of the 450 applicants since their employment constitutes a violation of their fundamental rights to work, dignity of the human person, and protection from inhuman and degrading treatment guaranteed under the 1999 Constitution and Articles 4, 5, 15, and 19 African Charter on Human and People's Rights Enforcement Act. 2. Declaration that applicants are entitled to regular and prompt payment of their salaries in accordance with National Minimum Wage Amendment Act 2024 and their continuous denial of same is unlawful, unconstitutional, and discriminatory. 3. Order directing respondents jointly and severally to immediately pay all outstanding salaries and emoluments due to applicants from the commencement of their respective engagements to date. 4. Another mandating the respondents to confirm or regularize the appointments of the applicants in accordance with the extant civil service rules and regulations governing employment in Sokoto State. 5. Order awarding general and aggravated damages in the sum of 500 million naira each to the applicants for the psychological trauma, hardship, and degrading treatment suffered due to the prolonged denial of their salaries and benefits. 6. Another directing the payment of interest at the rate of 21% per annum on all outstanding salaries from the respective due dates until final liquidation. And 7. And for such further order as this honorable court may deem fit to make in the circumstances. In support of this originating motion is 15-paragraph affidavit deposed to by Imran Abubakar, who is suing in his stead and in representative capacity, and a written address in line with the rules of this court. Upon receipt of originating process, respondents have brought a motion on notice dated 24th October 2025 and filed same date, which is brought pursuant to Section 6 sub 6, 254C of the Constitution of the Federal Republic of Nigeria 1999 as amended, and equally other 11 rules 1, sub-rule 1 and 2, 13, rule 18, order 13, rule 18, sub-rule 1 of the rules of this court. And equally section 7, sub-1, A, B, C of the Limitation Act 2004, and under the inherent jurisdiction of this honorable court. The motion seeks two orders as set here under. 1, order of court, striking out and or dismissing the suit of the respondent applicants for being incompetent, speculative, and lack of jurisdiction. 2, and for such other orders that this honorable court may deem fit to make in the circumstances. The application is predicated on 5 grounds enumerated 1 to 5 and reproduced below. The suit as presently constituted is against the wrong respondents. 2, Fundamental Rights Enforcement Procedure Rules 2009 does not contain provisions for filing a suit in a representative capacity. 3, the suit as presently constituted does not disclose a cause of action against the applicant respondents under the Fundamental Rights Enforcement Procedure Rules 2009. 4, applicants lack the local standard to commence the instant suit on behalf of the other unnamed 449 applicants. 5, applicant suit is statute barred. The affidavit in support of application was deposed to by one Mohammed Bala Yashau, a litigation secretary in the respondent applicant's counsel law firm. It is of 6 paragraphs with a written address filed alongside. Counsel to the first and second defendant applicant formulated 6 issues for determination as follows: whether the suit can be initiated via class action in a representative capacity. 2, whether applicants have the requisite local standard to institute the action on behalf of 449 others. 3, whether the subject matter is not a fundamental rights issue, but a purported employment dispute. 4, jurisdictional limits of National Industrial Court of Nigeria. 5, whether the subject matter of this suit discloses a cause of action against the respondent. And 6, whether the suit is statute barred. Submissions of first and second applicants. On the first issue, counsel submits that a fundamental rights action is personal and sui generis, and therefore designed for a single applicant seeking redress for a breach of his personal rights. He relied, among others, on Okoye versus CP Lagos State. Citation is provided. On the second issue, which is whether the applicant has the requisite local standard to institute the action on behalf of 449 others, applicant's counsel submits that the respondent has failed to fulfill the mandatory conditions precedent as laid down by law to institute a class action by not providing cogent and credible evidence of the consent and authority of those he claims to represent. Further buttressing his point, counsel reviewed the affidavit in support of complaint sworn by Imrana Abubakar in paragraph 2. And argued that the deposition is a bare assertion and a conclusion of law that carries no evidential value, and that this renders the entire action fundamentally incompetent as it relates to the parties purportedly represented. He cited in support the case of Macaulay versus MPA. On the third issue, yes, Bashina, come. Let's the video on. It's on. Okay. The third issue is whether the subject matter is not a fundamental right, but a purported employment dispute. Counsel relied on the Supreme Court position in PDP versus Silva that where a dispute is essentially about breach of contract or simply employment issues, the proper course of action is to seek remedies in contract, not under the fundamental enforcement procedure. That the respondents attempt to dress up their grievance, the purported non-payment of salaries for work done, as a breach of their right to dignity under Section 34 of the Constitution is far-reaching, and their reference to Section 17 of the Constitution is fatal to their case, as the section is non-justiciable, being provides under Chapter 2, Fundamental Objectives and Directive Principles of State Policy. Issue 4 is jurisdictional limits of the National Industrial Court of Nigeria. Applicants Counsel, relying on sections 254C, sub 1 and 2 of the Constitution, Fundamental Right Enforcement Procedure Rules 2009, submitted that this court lacks jurisdiction to entertain this specific type of action, a class action, filed under Fundamental Rights Procedure. He also relied on Section 2A Public Officers Protection Act, LFN 2004, with reference to some of the workers that were engaged as far back as 2020, which provides that any action against a public officer must be brought within 3 months from the day the action occurred. Issue 5 is whether the subject matter of this suit discloses a cause of action against respondents. Counsel holds here that in this instance that where respondent applicant's grievance as deposed in the affidavit is the non-payment of salaries for work. Counsel holds that in this instance, respondent applicant's grievance as deposed in the affidavit is the non-payment of salaries for work allegedly done. The Supreme Court has repeatedly held that there is a clear line of demarcation between mere contractual disputes and fundamental rights violations. He cited Tukur versus Government of Taraba State and submits that the flaw in respondent's case is his failure to sue his actual employer based on the subject matter and respondent applicant's own alleged engagement through the Ministry of Health, while it is evident that his employment relationship is with the Sokoto State Primary Healthcare Development Agency. Counsel submits that the failure of applicant respondents in joining Sokoto Primary Healthcare Development Agency as party in this action is a fatal omission and claims that this action is not a genuine effort to resolve a legal dispute, but a strategic attempt to create political pressure by naming the state government, thus constituting an abuse of court process. Issue 6 is whether the suit is statute barred. Applicant counsel submitted here that by virtue of Section 2A Public Officers Protection Act, LFN 2004, any action against a public officer, including the state government and their agencies, must commence within the statutory limitation period prescribed by law. In this instance, within 3 months from the day the cause of action approved. He submitted that from the claims of respondents, some of the affected workers' employment relationship dates back to the year 2020, while this action was filed August 2025. Hence, the action against them is statute barred. Furthermore, counsel holds that this suit contravenes Section 7 sub 1A to C of Limitation Act 2004, which prescribes specific limitation periods for actions not otherwise covered by particular statutes. The contractual withholding of salaries being a contractual and employment matter falls within the 6-year limitation period. Therefore, this suit is statute barred and incompetent. He finally urged the court to strike out and or dismiss this suit in its entirety with substantial cause. Respondent submission. In opposing the application, respondent on 3rd November 2025 filed a counter affidavit of 12 paragraphs deposed to by Imran Abubakar, that's claimant hearing, and written address where counsel formulated 3 issues as follows: whether this court lacks jurisdiction to entertain the substantive suit as contended by the first and second applicant respondents. 2, whether the suit constituted discloses a reasonable cause of action under Fundamental Rights Enforcement Procedure Rules 2009. And 3, whether applicant's suit is statute barred in view of continued violation of their constitutional and labor rights. On the first issue, counsel submitted that by Section 254C, 1999 Constitution as amended, this honorable court has exclusive jurisdiction over all matters relating to labor, employment, condition of service, welfare of workers, and connected matters, including the enforcement of fundamental rights arising from same. He further relied on National Judicial Council versus Aladejana and others, where the Supreme Court affirmed that the NICN can entertain matters involving alleged breach of fundamental rights, where such rights are connected to an employment relationship. On the second issue, counsel submitted that the deprivation of salaries and entitlements for over 5 years, while the applicants remain in active service, under the applicant's supervision constitutes not only economic oppression, but also forced labor, inhuman and degrading treatment, and a denial of dignity of the human person, all prohibited by Section 34, 1, 34 sub 1 and 42 sub 1 of the Constitution and Articles 4, 5, and 15 of African Charter on Human and People's Rights. He further relied on Ekiti State versus Olubomo, where it was held that non-payment of salaries to workers amounts to breach of their constitutional and human rights, properly enforceable under Fundamental Rights Enforcement Procedure Rules, 2009. On the issue of representative capacity, Council argued that based on the provisions of paragraph 3E of the preamble to the Fundamental Rights Enforcement Procedure Rules, 2009, that says the court encourages and welcomes public interest litigation in the human rights field, and no human rights case may be dismissed or struck out for want of local standard. The respondent having sworn that he was authorized by the 449 affected workers to represent them has satisfied the requirement for representative capacity. And on the third issue, whether the applicant's suit is statute barred, Respondents' Counsel stressed that Public Officers Protection Act does not apply to cases of continuing injury or damages, nor does it protect public officers acting in breach of the Constitution, that the non-payment of salaries from 2020 till date is a continuous injury, renews each month the applicants, remain unpaid. Counsel emphasized that a continuous injury gives rise to a fresh cause of action each day it subsists. He cited RMO versus Adekoyin. He further mentioned that fundamental enforcement actions are sui generis. They are constitutional proceedings aimed at protecting human dignity and liberty. He placed reliance on Fawehimi versus Abacha. He finally submitted that the respondent is not seeking gratuitous benefits, but enforcement of earned wages for years of legitimate service rendered to the Sokoto government, and that the applicant's respondent's position that these workers should be shut out on procedural technicalities is offensive to the principles of equity, justice, and constitutional government. Now, the decision of the court. I have carefully considered both the originating process and the application to strike out or dismiss these suits. It is proper to resolve the motion to strike out or dismiss first, as its success or failure will determine whether the court has jurisdiction to consider the substantive case. I believe, Counsel, you are still connected.
Yes, my lord.
All right, thank you. From the grounds upon which this application for another striking out or dismissal is brought, I have surmised a sole issue for determination, to wit, whether this court has the requisite jurisdiction to hear and determine this matter as presently constituted. I am also inclined to adopt the issues formulated by the applicant. However, that will be dependent on the resolution of the issue distilled above. Where the court finds that it has jurisdiction, I will then proceed to address the issues raised by the applicant. The issue of jurisdiction is forefront, as it is settled law that jurisdiction is the life wire upon which a court proceeding rests. Where a court has no jurisdiction to entertain an action, its decision, no matter how brilliant or carefully arrived, is null and void. See AG Bauchi State versus AG Federation, 2018, 17 NWLR, Part 1648 at 299. It is right that this Honorable Court is a superior court of record, established under Section 254A of the Constitution of the Federal Republic of Nigeria, 1999, as amended. By virtue of Section 254C1 of the Constitution, the National Industrial Court of Nigeria possesses exclusive jurisdiction to hear and determine matters relating to labor, employment, trade unions, industrial relations, and any disputes arising from the payment or non-payment of salaries, wages, pensions, gratuities, allowances, benefits, and any other entitlement of any employee in any part of the Federation. Furthermore, Section 254C 1D expressly confers on this court jurisdiction over matters relating to or connected with the interpretation and application of the provisions of Chapter 4 of the Constitution, including fundamental rights disputes arising from workplace relationship. In the instant application, the applicants have challenged the jurisdiction of this court to entertain the suit commenced by the respondent for the non-payment of salaries and other emoluments owed to 450 applicants alleging a violation of their fundamental human rights. A perusal of the originating motion, particularly reliefs 1, 2, 3, and 4, discloses that the claims are predicated on the non-payment of salaries and the failure to regularize the appointment of the respondents. Paragraphs 3 to 8 of the affidavit in support of originating motion depose to facts relating to the employment relationship and the delay or failure to pay salaries due to the respondent. Paragraphs 10 and 11 assert that such failure amounts to a violation of the respondent's right to dignity of the human person and constitutes discrimination. It must be stated firmly that claims founded strictly on the non-payment of salaries and regularization of appointments, as in the present case, do not ipso facto constitute a breach of fundamental human rights within the contemplation of Chapter 4, 1999 Constitution. The respondent applicant has not demonstrated how the alleged non-payment of salaries translates to a violation of fundamental rights. The Supreme Court in Tuku versus Government of Taraba State, 1997, 8th Nigerian Weekly Law Report, Part 518 at 579 held that where the principal claim is for breach of contract of employment and the allegation of a fundamental rights breach is merely incidental or afterthought, the proper forum is the court of competent jurisdiction for enforcement procedure rules. See Egbuonu versus BRTC, 1997, 12th Nigerian Weekly Law Report, Part 531, 29 Supreme Court. Equally, Ezeanoche versus Igwe, 2020, 7 Nigerian Weekly Law Report, Part 1724, 430 Supreme Court. All to the effect that for a claim to qualify as falling under fundamental right enforcement procedure rules, the principal relief sought must be for the enforcement of fundamental rights as envisaged in Chapter 4 of the Constitution, and not to address a grievance that is ancillary to deprivation of fundamental rights. Accordingly, I hold that the claims filed by the claimant respondents were wrongly brought under the Fundamental Rights Enforcement Procedure Rules. This court therefore lacks jurisdiction to entertain the suit as presently constituted. The entire suit is hereby struck out. I so hold.
As the court
Having
pleases.
struck out the case for want of jurisdiction, it is unnecessary to consider the merits of the case. The respondent is at liberty to institute an action by appropriate mode of commencement before this court. Ruling is entered accordingly.
As the court pleases.
As court pleases.
All right, counsel. When you have people file this thing, why do you do this thing this way? Do we have any counsel in court regarding this? Okay, no. So for this, are you in what number are you counsel?
Number 4.
Give me where is the file for this ruling? Are you making use of it?
Yes, sir.
Okay, when you finish, give that to take to the last correct. Yes, call. No, why are we going to number 4? Huh? What of number 3? They are both for continuation of hearing. We follow the course list.
My Lord, I'm sorry, my Lord. I don't know if my Lord can indulge me and call it out of turn because I have another matter before your learned brother in the FCT High Court.
Okay.
So that's why I said, let me take, because my Lord sits early. Thank you, my Lord.
So that's number 4. So let's Abbas.
No, Fahad.
No,
Fahad
just
Musa.
hold on. I want to inform the Sokoto. Yes. It's number 3. Okay, he's in number 3, not 4. Okay, so it's okay.
Oh, okay.
So it's your number. Yes, so call Abbas.
Yes, my Lord.
Yes, call the next matter, please, on the course list.
Okay, my lord. NICN /SK/02/2024 between Haastrup versus Medicine Champion. My lord, the case is for defense.
Do we have parties in courts there?
Yes, my lord. Okay.
We don't have them in court, but they are online.
Parties are absent.
No,
Online?
Yes, my lord.
the defendant is represented online.
How about the claimant?
My lord, the claimant is online.
Yes.
Is he online?
Fahad Musa.
Yes, let's see.
Present, my lord.
Okay, yes, I can see. Claimant is present.
The defendant is represented by Ira Hindolo Johnson.
I can't see the defendant here.
He's there, my lord. He's wearing glasses.
I'm here, my lord.
Okay. What's the name?
Ira,
Ira
I-R-A.
Idolo Johnson.
Yes, my lord.
What's your designation? Defendant?
Sorry, Mr. Indolo, what's your position?
I am a human resource and a finance manager working for MSF.
All right.
Thank you, Mr. Johnson.
Yes, appearance of counsel.
May your lordship be pleased. My name is Ali Jibril, appearing for the claimants.
Sorry, counsel, we have a hitch here. Where is Bashima? She has gone out. The system has gone off. This is the problem we have with it. Are you still connected?
We are still connected.
Yes,
But I can't see. Hold on.
I can see Mr. Jibril.
All right, let's see. Okay. All right. Yes, appearance. Aliu Jibril. Is it Jibrin or Bril?
L, my lord, L.
L. Okay. Yes, defendant's counsel, please.
May it please, my lord.
Yes, you are the
I am
defendant.
Malam Muhammad Shuaib. I respectfully announce my appearance for the defendant. My lord, I appear with I.O. Aigbe.
Spell the last name.
Aigbe is A-I-G-B-E. Mrs.
Yes, counsel.
Lord, the case is slated for defense.
Yes.
We have our witness, Mr. Johnson, who is in Faraway, Sierra Leone. He's ready to give evidence virtually.
Okay, he's online.
He's online, yes.
My lord.
Claimant's counsel, are you ready?
My lord, the claimant, if the claimant could remember, my lord, they only filed a motion for extension of time.
Hold on. Hold on, please.
Yes, my lord.
Yes, Jibril, what's the issue now?
The claimant filed a motion for extension of time, which was moved on the 24th day of July 2024. And since then, my lord, the claimant has been seeking for adjournment to file their defense.
Is it claimant or defendant?
Sorry, the defendant, my lord.
Yes.
which unfortunately they did not.
They did not file.
Yes, my lord. Including the witness who is about to give testimony, who is about to testify, there is no statement on oath. In fact, the entire process of defense was never filed.
Please come on. Check. Yes, let's hear from defendant. Can you heard him? He said even the witness that is about to give evidence now has no written statement on oath, and there's no statement of defense filed. So maybe you wish to respond before the court checks its records.
Another, we filed on the 25th of April 2025 at 1:30 p.m.
We'll find out if the claimant was served with that.
Well, I assume that they have been served.
We can't be assuming, so we'll check the records. Just hold on, Jibril. Let's check. The record speaks for the court.
Stop, please.
You said 25th April. Yes, so you check. Yes, it's to check if the claimant was served. If he wasn't served, then it's as good as not filing anything.
Then it's a breakdown in communication, Mola, but
yes.
It's not because we have not filed that, but I think because the claimant has not been served. So there's a mix-up somewhere.
There's no proof of service in the file.
I understand that, my lord.
Abbas, yeah, even if he has it, the claimant was not, even if let's confirm from Sokoto. Abbas, do you have the process of the defendant filed on 25th April? Because for my records here, there's no proof of service on the claimant.
No, my lord, we didn't on that day.
So, Defendant Kasa, you can hear the registrar from Sokoto said he's not received any process. I don't know, but where did you file it?
We filed it in Abuja here, sir.
You see, it's Abuja, so it ought to have been transmitted to Sokoto. So, counsel, even if you file, you don't fold your arms. You have to follow up to see how it will be transmitted to Sokoto.
As a company, yes. We'll do that next time. But,
so there's no proof of service.
We filed it in Abuja, and wait, let me just leave it at that. I don't want to.
All right.
I don't want to go and be.
So, counsel, you do the needful, please.
We will do that, my lord. Sometimes it's better to let sleeping dogs lie. We will make the necessary arrangement and have the process transmitted to Sokoto for the claimant to be served. Mr. Ali, sorry for the mix-up.
It's all right.
Or if my lord will grant us leave,
yes,
we will send directly to Mr. Ali's office by FedEx.
Yes, he can hear you now. Jibril, you can hear him?
Yes, yes.
So it's going to be sent to your office. He's undertaking to do that.
I'm undertaking to do that. We'll send it directly.
So when you send, I need the proof of service here for the records.
We'll do that.
I'll put you on record.
Put me on record. Right.
So let's give them another date.
Haastrup, please.
May we be guided by the court's earliest convenience?
Can you check when we have the Sokoto? Oh, we give. Okay.
I hope it will be first week of July.
Okay, so let's look at first week of July.
Yes, first week of July will be fine.
Okay, I think both.
Sorry, Mr. Johnson, would that be convenient for you first week of July?
I think so. I can always find time.
Thank you.
Is it a clear date? Are you sure? Okay, you can take it. 3rd of July.
It's a Friday. It's convenient for us.
Yes.
It's convenient.
Sorry, my lord.
3rd July, 03.
3rd of July.
Yes.
Haastrup, please.
Okay.
So
that's do we agree for 10 o'clock or 9? 10. I think preferably 10.
10 o'clock, my lord.
All right.
Sorry, my lord. Lion Council.
Yes.
My Lagos office, not Sokoto.
Your office is in Lagos?
Okay, you heard the Claimant Council.
Okay, can you please send me the address?
He's on our process.
All right.
Okay, no problem.
So, Council, you note that so that we don't have a hitch on that next day again.
No problem.
So
we'll send it
the
to Lagos.
service of the process to be at the claimant's office in Lagos.
No problem. We'll do that, my lord.
All right. Okay. So upon agreement of counsel, case is further adjourned to 3rd day of July 2026 for definite defense. The defendant counsel shall serve processes in defense on claimant's counsel before the next hearing date at the claimant's Lagos office. Claimant counsel's Lagos office. Furthermore, defendant witness shall be present virtually for trial, and the virtual sitting shall be by 10 a.m. So the case is adjourned.
We are most grateful, Your Majesty.
You're welcome.
Ms. Ira, you can leave.
Thank you very much.
Thank you, witness. Yes, you can now exit the platform. Thank you.
Oh, okay.
Abbas, you can call the next case, please.
Please, madam. NIC SK /08/2024.
Abbas.
Yes, my lord.
Please hold on. Yes, learned counsel in the previous matter, you can take your leave. Others are done. The other matters are still virtual, so we'll proceed that way. Yes, Abbas, go ahead, please. Call the next case.
Please, my lord. NIC and case /08/2024 between Said versus Development Action Center. My lord, the case is for defense.
Do we have any of the parties in court or online?
Parties are in court.
They are in
No,
court?
my lord.
Are they physically in court in Sokoto or online? If they are online, counsel, please confirm.
No,
Yes. Claimant, are you online? Saidu Garba, Janjan. Is absent.
My lord, all the parties are absent, my lord.
They are absent. I can't see any name like that here. Appearance, please.
Okay. My lord, there is the defendant.
Sorry?
There are representatives.
Okay, I'm coming there. So claimant is absent. Defendant represented.
Yes, my lord.
Represented by who? What's the name?
Your name?
My name is Samuel Sani.
Samuel who?
Sani.
Is it Simon or Samuel?
Samuel.
Spell the other name.
K-O-N.
Yes.
T-O-N.
That's easy.
G-S.
K-O-N.
T-O-N-G.
T-O-N-G-S. Yes, what's your designation there?
I'm the acting human resources.
Acting human resource.
Yes, ma'am.
HRN.
Yes.
Appearance of counsel. Why? Gwazawa.
Yes, madam.
How about defendant counsel?
Name, please, my lord. LS Ibrahim. Another appearance for the defendant.
What's the name?
LS Ibrahim.
The last person that represented the defendant here is it NL Sumi?
Was NL Sumi.
So you are Ibrahim, you said?
Yes, I am LS Ibrahim.
Okay, let me have the LS Ibrahim. I can see the name. I just saw Sumi here for the last. Okay. LS Ibrahim for defendant. Yes. Yes, sir, counsel.
Yes, my lord. Yes, my lord, the matter was for defense.
Okay.
Subject to court.
Are you ready?
Yes, my lord, subject to court convenience, we are ready.
Where is the witness? He's in court, Abbas. Okay.
Yes, my lord. He's in court.
Okay. Do the needful there.
Let's go, please, my lord. Just wait. My lord, you can see him.
Yes, I can see him. Yes. Let him go into the witness box.
Yes, my lord. He entered witness box, my lord.
Yes, so you do the needful. Ask him, does he want to, is he a Muslim, a Christian? Does he want to affirm or swear?
I want to affirm. I want to affirm.
Is he a Muslim? Is he a Christian?
My Lord, you want to affirm?
Okay.
Yes. Said after your name. I,
Samuel Kontosani,
do solemnly affirm that
do solemnly affirm that
all the witness
I shall give
in this case,
All
in
the
this case,
evidence I shall give. Excuse me.
all the evidence I shall
The
give,
evidence I shall give.
in this court,
all the evidence
Okay.
I shall give in this court,
Exactly.
in this case, before this court,
in this case before this honorable court,
shall be the truth,
the
whole truth,
truth,
nothing but the truth.
nothing but the truth.
My
All
Lord,
right. Thank you. All right. Thank you. Yes, Counsel.
Once again.
My name is Samuel Kontosani.
Yes, Counsel.
Yes, what do you do?
I'm a development worker. I'm a development worker from Development Exchange Center, number 5, Kaduna Road.
Hold on.
Yes.
Yes, number what?
Number 5, Kaduna Road,
Yes.
off Amadu Bello Way,
Yes.
Bauchi State.
Yes, Counsel.
Do you know that in this matter?
Yes, I do.
Yes.
What is your position with the defendant?
I thought he had stated it. He said he's a
I'm
development
the acting human resource
development
manager.
worker. Sorry?
I'm a development worker, and my position is the acting human resources manager.
Okay.
Yes.
Yes.
Do you remember giving your witness or before this honorable court?
Yes, I do.
Yes.
If you see the statement, how will you identify them?
When
Yes,
did he depose to that statement or no, Counsel? What date?
24th day of March 2025.
All right.
Yes.
24th day of March 2025.
Yes.
Okay, if you see the statement, how will you identify?
Yes, I can identify it by the content, the positions, my name, and my signature.
Yes. Yes, show him, let him confirm if that is the statement.
Yes. Yes.
Yes, witness. All right.
Yes, I confirmed. Yeah.
Yes, Counsel.
Yes, I want this honorable court to adopt this statement as my testimony in this before this honorable court.
Yes, Counsel.
My lord, the witness have identified the first statement may apply.
It's on record already.
Statement be adopted as his evidence in chief before this one.
All right, yes. Yes, counsel.
Yes, witness.
Yes, sir.
Yes, witness in paragraph 4 of your witness statement on oath. A termination letter dated the 21st of February 25. She said later. How will you identify them?
Thank you. I will identify it by the letterhead of Development Exchange Center and the contents therein.
Yes.
Yes, my lord, may I apply to say the witness document?
Please refer him to those. What to save time? Just refer him to the paragraphs where those documents have been mentioned, and then you now, if you need to lay foundation for any, you do that. Then you show him all the documents at once.
Okay, as the court
to save time, just refer the court to those paragraphs where those documents are mentioned.
Yes, my lord. The first one is paragraph 4, where the document was marked A.
As you are referring to the court as well, witness must follow your, I don't know, the way you are referring to those documents. So you can refer him, you say paragraph 4, social documents, you refer to social documents, your paragraph 4, paragraph 5, paragraph 6, and so on and so forth. And you now show him those documents. If those are the documents he wants to rely upon, then we now hand over to the claimant's counsel. Yes. And where you need to lay foundation regarding any in between, you can do that alongside. Yes.
As the court Mr. Witness, also in paragraph 23 of your statement that was just adopted, you make mention of debt policy and procedures. Paragraph 23. Paragraph 23.
Okay, 23.
Mark as Exhibit L.
Yes, yes.
Mark as Exhibit L.
Yes, go ahead.
Yes, then another document you made mention of is paragraph 26.
Yes.
A response letter from the claimant, which is marked as Exhibit M and
yes.
Then paragraph 6 of the defendant counterclaimant make mention of guarantor's form, which are marked as Exhibit 1. If you see those exhibits, how will you identify them?
Thank you, sir. I will identify it, first of all, for the policy. I will identify it by the cover of the policy handbook, which has Development Exchange Center logo and also the contents of the policy. Then for the M and M1, I will identify it by the logo of our El Sabo Associate. Also the content therein. Then for the guarantors, I will identify it by their names.
The names of
the guarantors.
My lord, may I apply to show the witness the said documents?
Show him. Where did you refer to that last exhibit, which you refer to as exhibit 6?
Paragraph CC1, paragraph 6 of the counterclaim.
Okay.
Yes. Exhibit CC1.
Exhibit paragraph 6.
Yes, paragraph 6.
Of the counterclaim.
Of the counterclaim.
All right. Yeah, show him the documents, please.
Yes, I could see for the operational policy. Then I have the macro credit policy having DEX logo. Then also the termination letter having the letterhead as I earlier mentioned. Then for the guarantor sum also I have it here for Inusa Garba Janjang and Peter's Jet Ipa. Also for the M and M1, I have it here for AR Stable Associates, as I earlier mentioned, and the M1 is here behind it. Thank you.
Yes, my lord, they wouldn't have any divided set documents. May we apply that the documents be tendered as an exhibit? All the documents were updated. I most welcome.
Yes, Claimants Council, pass the registrar, pass the documents to the Claimants Council. Is the Claimants Council physically in court? Claimants Council.
Yes, my lord.
Are you online or physically in court?
Yes, I'm in court.
Okay, all right. So those documents were front-loaded?
Yes, we are controlling. We are not opposing.
Oh, all right. I didn't hear you. Okay. Yeah, so we take them one after the other. I will check where is so I have to check from my own records here. We will take them one after. So the Claimants Council is not opposed to the document. We'll take so Defendant Council, you start from the first document. I will check from my own records. Since the documents are there in Sokoto, and the registrar, please, you pay attention as well. So we start with the first document. Yes, Defendants Council, please, let's have the first document.
The first document is the termination letter.
Hold on, dated when?
Dated the 23rd of February, 2025.
That's exhibit what? That's why they marked it.
Exhibit A.
Exhibit what?
Exhibit A.
No, exhibit A here is
payment demand.
Exhibit A here is suspension letter. It's not
yes, that's suspension / payment demand.
Oh, okay, that's okay. Suspension. Abbas.
Please, my lord.
Have you seen that document?
Yes, my lord.
Okay.
The document is me, my lord.
It's marked as Exhibit A.
Exhibit A, my lord.
Yes. What I have there is dated February 21, 2025.
2025,
yes. Yes, titled Re-Suspension Stroke Payments Demand. All right. Yes, my lord. Yes, Defendant Counsel, so that is admitted in evidence, marked as Exhibit A. Yes, Defendant Counsel.
Yes, my lord, the next document is Exhibit L.
Yes.
which is the policy and procedure.
Exhibit L.
Yes. Jet personal policy and procedure.
M. L comes before M. JK. L. What's the title, please?
It is titled Jet Personnel Policy and Procedure 2018.
Okay.
Together with the microcredit manual. All of them were tagged as Exhibit L in the Statement of
Yes,
Defense.
that's for year 2018.
2018, yes.
Abbas,
Yes, my lord.
do you have that document with you?
Yes, my lord.
Okay. So the second document is titled DEC Personnel Policy and Procedures 2018. Is admitted in evidence and marked as Exhibit L. Yes, defendant counsel. The next.
Yes, my lord. The next is a response letter from the defendant counsel, marked as Exhibit M and M1.
Yes, the letter respectively dated, the first one I have here is dated 27th November 2024. Is that it?
Yes.
And the other one is EMS parcel. What's this? Is it what's this one? From EMS parcel Nigeria. What's this? It's a courier stop also. Is that it?
Yes.
Okay.
Yes, my lord.
So 27th November. So we have the response letter from defendant's counsel dated 27 November 2024, AK Sabo and Associates, and equally EMS Parcel Nigeria Stop exhibit marked as Exhibit M and M1. They are all admitted in evidence.
I
hope, Registrar, you have those documents.
Yes, my lord.
All right. Defendant counsel, please proceed.
Yes, my lord. The last document is Exhibit CC1, the guarantor's form.
Exhibit CC1.
CC1. The two guarantors form.
Yes, we need to find out where that CC1 is. I have C now, but I'm yet to cite that CC1. You said it's the one that is you mentioned in the counterclaim.
Yes, in the counterclaim.
Okay. Paragraph 6. Yes, CC1. What's the title of the document? It's addressed to who?
It is a guarantor form by Peters J. Gildam and one Ilwa.
It's a guarantor form signed by who?
Signed by the guarantor on standing as guarantors to the claimant.
I have two documents. There's CC. Is it CC what? Oh, they are both CC1.
Both the two documents are marked. There are two guarantors, but both the documents
All right, okay. I have the two here. Yes, Abbas, do you have those two documents?
Yes, my lord.
All right, still marked as the exhibit CC1.
As please, my lord.
Yes, Council.
Yes, my lord, that's all for this, my own part.
All right. Claimants Council. Gwazawa, yes.
May I humbly ask the reader of the court how the exhibit was extended?
Please, you have to speak. I hope the network will permit us. Yes, Council. It's for cross-examination.
Yes.
Can you proceed, please?
Thank you, my lord.
What are you showing him? What document is that?
Exhibit A.
Exhibit A.
Exhibit was issued on the 21st of February 2020. Is that correct?
I can't hear your question. Please, Washima, you have to come here. Where's the exhibit A? What's the question?
My question is that Exhibit A was issued on the 22nd, was dated on 21st February.
Okay. He said it was issued on 21st February.
It was dated
2025.
Yes.
Yes.
Yes, Council.
This instance was filed before this letter was sent to the claimant. Is that correct? This letter was filed from the claimant after he has filed his case before this honorable court.
We have sent this letter on the 21st. Well, I can't remember the exact date that he filed this case, but this decision was made based on the management's approval.
That's not his question. He said that letter was served on claimant after he filed this suit. So just tell us if that is that was what happened.
Yes. The question is that it was served after when the case was pending before this honorable.
Yes.
You said it was served on the claimant after he filed this suit.
After the pendency, during the pendency of this case.
Okay, when the matter was already in court. Yes, is that the position? Yes, witness, what's your response?
Yes, my lord.
Yes.
You alleged in your counter affidavit that there is poor on the part of the claimant. That is your allegation. Is that correct?
Not an allegation, but that's the true picture of what really transpired.
Counsel, I can't hear you, please.
I asked them that they alleged, the defendant alleged that the claimant has a poor supervision.
Can you hear me? Claimant's counsel, are you resident in Sokoto?
Yes, my lord. Yes, my lord.
Are you in the courtroom there?
I'm in the courtroom, my lord.
You are in the courtroom?
Yes, my lord.
Since the network there is very poor because I can't hear you. Abbas.
Yes, my lord.
What's the problem? I can't hear, and I need to get these questions. I need to get the questions. So if he needs to move closer to you, please. I can't hear him.
Sorry, my lord.
All right. You said he alleged that the claimant did what?
The claimant, because of his poor supervision, that is why they issue Exhibit A.
That they allege that the claimant did what?
Because of his poor supervision, that is why.
Okay, because of his supervision of the claimant, that was why they issued the Exhibit A.
Yes.
Okay. Yes, witness.
Yes, my lord. We are not alleging. That's the true picture of what really transpired, and is in line with this decision was not taken unilaterally. We have aligned it with the policy of the organization before we reach this conclusion. Thank you, my lord.
So you say it's not an allegation.
Yes. It's not an allegation.
Yes, counsel.
Yes. Yes. When you made that allegation, was there any time that you invited the defendant to make response in respect of the allegation? Was there
any defendant or claimant?
Yes, the claimant.
Yes, witness.
Yes, thank you, my lord. Respond to this question. Organization, we mustn't invite the person. We have our channels of communication, one of which we issue queries, which gives an employee the opportunity to express him or herself as regards whatever investigation has been carried out, and that has been done. And
hold on. You said you have your line of communication. Yes. That you issued queries. Yes.
Yes, because what you asked whether we have invited him in person, but I'm trying to communicate these issues to him, and one of which is queries be required to know what really happened, and also give him a fair and share. That's another way to respond to it, and that has been done. The court witness who is within this honorable court, that is, we will later talk about it because.
Counsel, witness, I think this response is very, very vital because I can't really hear you. I can't. The background is not clear enough.
Yes, ma'am. The network is breaking from here.
Yes, it's from your end. Yes, I can't really hear you. So you may have to keep repeating until I'm able to hear you.
No problem, ma'am.
All I heard here now is that your line of communication, that you have your line of communication and you issued queries. So are you saying that, because I don't know if I actually got you right, did you say that you don't have to invite the claimant?
Yes, ma'am.
Did you say that?
Yes, ma'am.
Okay.
Yeah.
Did you say that?
Yes, ma'am.
So yes, continue. Yes.
Yes, ma'am. That's
Okay, that is all. You said you have your line of communication. You issue queries and you don't need to invite the claimant.
I communicated to him.
Okay.
Yes. Our findings.
Okay, you communicated your findings to the claimant.
Yes, ma'am.
Yes, counsel.
Yes, my lord. My lord, in paragraph 14 of your statement of claim, you make reference that you have set a team to investigate the matter. Is that correct?
Yes. Is it statement of claim or statement of defense?
Statement of defense. Sorry, my lord. Statement of defense.
Yes, what's in that paragraph 13?
Paragraph 14.
Is it 14 or 13?
14, my lord.
Okay,
sorry,
14.
14. Yes, my lord.
Yes.
Yes. I asked him, they say they have set a committee to investigate the issue raised. Is that correct?
It has been done.
Paragraph 14. 14.
Yes. Witness,
Yes.
claimant counsel, can you read out that paragraph 14? Because it doesn't have it with him.
Yes.
Can you read out the paragraph 14 of the statement of defense?
Yes, my lord. Furthermore, as a result of the claimant's response in paragraph via Exhibit 1, a team was set up to investigate what was going on in the branch.
Yes, witness, do you agree with what you have?
Yes, we have sent a team when we discovered that there were discrepancies in the report of the claimant. So an independent audit committee was set up who went to the branch and carried out investigations before we arrived at the conclusion.
So my question now is, who headed the said committee?
The committee was headed by the audit team.
The committee was headed by who?
Andrew Samuel.
Sorry?
Mr. Andrew Samuel, head of this from the audit department.
Head of the audit department.
From the audit department, head of his audit.
Yes.
Where was the investigation carried out? Is it in Bauchi or in the branch where the alleged discrepancies happened?
The investigation was carried out at Zuru branch, where the misappropriation happened. They traveled from Bauchi to Zuru branch,
the investigation was carried out where? The branch.
Zuru branch in Kebbi State.
Okay, Zuru branch, Kebbi.
Yes.
Yes.
Yes. Was the claimant present before they round up their conclusion?
The claimant was not present. We, after the investigation, we have issued him query based on the findings so that he can respond to it, and that's the way of giving a fair hearing to an employee while we are doing the investigation. While we have the we are having conflicting reports. So an independent
you say you issued the claimant with a query?
A query, but he was not there when they are doing the
yes, I put you on record already. You said the claimant was not present there.
Yes.
When the investigation was carried out in Zuru branch.
Yes. Yes.
But that you issued the claimant with query before now, and that to you is fair hearing.
Yes. Yes.
Yes, Counsel.
Where is the query issued to the defendant?
Yes.
Where is what?
The query, he said, they issued to the claimant. Where is the query?
Yes, the query will be made available by my colleague who is in the court.
But is the query before the court?
Yes, it's available in the court.
Okay, let us have the query.
Yes.
Sorry, not the tender.
You can tender it to the company for now.
Yes.
Yes.
Was the query amongst the documents you tendered before the court?
No, it has not yet been tendered.
Okay.
Not yet been tendered. We'll be taking
Yes,
it to other woodlands.
Yes. So the query is not before the court?
It's not. They say it's before the court. It has not yet been tendered.
Okay. All right. All right. Go ahead.
Yes. Yes. In your paragraph 18 of the statement of defense.
Paragraph what?
Paragraph 18, my lord.
18.
Yes.
Yes.
The claimant made a request in which you refused that let him be given facility to be going to Zulu to carry out the work efficiently, but you refused. And you deposed that in your paragraph 18.
Okay.
Yes, read it.
Yes. The decision by the defendant not to grant his request to go and audit was made due to the report received by the operation unit regarding his appropriation of funds at Zuru branch, in which there was no comprehensive report from claimant in the area field internal auditor.
Yes.
Yes. He made a request that you should make a provision for him to go and carry it out, and you refused.
Thank you.
Is that correct or is not correct?
It's not correct.
What is not correct? What was the question?
The question is that the claimant, in order to carry out effective auditing, he made a request that they should make a provision for him to go and carry out the audit, but they refused to grant the request. As over in paragraph 18 of the defendant's statement.
So what's your response, witness?
My response is correct.
What's your response? I can't hear you. That you didn't grant the request to the claimant to go and audit.
Yes, we haven't granted him the request.
Sorry?
We have not refused granting you the request.
Okay, you didn't refuse that. So you say it's not true.
It's not true.
Okay, but that's your evidence there. Okay, you said it is not true.
It's not.
Yes, counsel.
Yes. In your exhibit, I think exhibit M. Exhibit manual. Exhibit M. Exhibit L.
Is it L for Lagos or M?
L. Exhibit L.
Okay, L. Okay.
Yes. For operational policy and procedure.
Yes.
Yes. Specifically, I'm making reference to page 22.
Yes.
And the disciplinary. Okay, misconduct. Sorry, my lord. Sorry, my lord. Okay.
Yes, Exhibit L, page 22, you said?
Yes. Exhibit L, page 20, 22, 23.
22 to what?
To 23,
Yes.
yes. They have made reference to the disciplinary action. The defendant made reference to the disciplinary action in Exhibit L.
Yes.
Is that correct?
Yes.
Yes, Counsel.
Yes. In that page 20.
In page what?
Page 22.
Yes.
Yes. Page 22.
Yes, go ahead.
Yes. That if you are hearing today, anybody who is being queried and even give him another opportunity to present documents and witnesses. Is that correct? Yes.
Counsel, what's claimant's counsel? Please, I can't hear you. What's the question? You have referred him to disciplinary actions or whatever in pages 22 to 23.
Yes,
you now went further to ask him. You referred him again to page 22. So what's your question?
Yes, my question is that in the manual, there is a provision for fair hearing of anybody queried by the defendant.
Yes, witness.
Sorry, my lord.
Yes, you say in that manner there's a provision for fair hearing for anyone queried by the defendant.
Yes.
Yes, witness.
Is that correct?
I think that's all we have.
Is there that provision in your manual?
It depends on the process.
It depends on what? Did you hear him? He said that manner there's a provision for fair hearing for anyone queried by defendant.
It depends on what you really define. Because when I'm presenting this document here, I want to make this comment.
Your network is very bad. Just a lot of strength.
The defendant, the claimant brother, he was an employee of the micro credit department at the State Internal Hospital. And I will to the chapter 11.
Counsel, please, you have to answer you have to be straightforward because the network there is very poor. I can't continue to stress myself this way. The network is very poor. So please answer your questions directly. If you need to refer to any place in the manual where there's a provision for fair hearing, refer the court there. If there's nothing like that, then you tell the court and save the time because the network there is very poor.
Yes, I'm making reference to there is a provision there, 7.06, paragraph E, at page 22. It has specifically mentioned that anybody queried must be given an opportunity, including presenting documents, calling witnesses. So I just want to ask him, did the defendant give the claimant opportunity to call witnesses or to present documents in respect of any allegation that you queried him? Did you do that?
Sorry, my lord.
We have given him.
My lord.
Yes, you're asking him if witnesses were called and documents presented to claimants.
Yes.
Is that not what you're asking him?
Yes, my lord. That the witness, what I'm trying to ask now, that the claimant was never given any document for specific allegation and was never given an opportunity to respond or to present documents or to call witnesses to support what he responded.
Yes, you heard the claimant counsel that because by your manual that there's provision for fair hearing with what he has stated. Was that applicable to the claimant?
It was, ma. We have given him fair hearing.
So you say you applied that provision as regards the claimant. So you are saying that you gave him fair hearing.
Yes, we have given him fair hearing.
Yes, claimant counsel.
Yes. What time did you give him fair hearing?
Yes. During my earlier submissions, I have made mention that one of the ways is through issuance of query, and that's an opportunity for an employee to express him or herself on any matter that he has been queried or any matter that has been investigated.
When you ask you a question, instead of you to answer directly, you give story. Just go straight to the board and answer my question.
Yes, that's what I'm responding to. We have given him fair hearing free of issuance of query.
He was never given opportunity to call any witness to support in support of his response. He has never given opportunity to call any witness.
There wasn't any
witness. He say was he given opportunity to call any witness?
He was given opportunity because during the issuance of query, the responsible if you have witnesses, you can present that.
When you say you didn't sit down with him.
Yes, we must not sit down with him.
Yes, counsel.
Yes. And he was not given opportunity to present any document. He was not even shown a specific allegation that he wants to respond to.
He has presented documents which we have presented to this court. I believe the next witness will present that one. Thank you.
Witness, what's your response, please?
Yes, the other witness will come with the document that they have presented to him.
Okay. We come with which documents?
Which document is he coming with?
Yes, the query is issued to him and his response, including the document he has tendered the defense. We have it available.
Did you hear his question? He said, was opportunity given to claimants to present documents in defense of his case?
My lord, I responded to that we have given him the opportunity for fair hearing. Yes.
Yes, claimants counsel.
My lord, that would like for this witness.
Yes, defendant counsel.
Yes, my lord, there's no examination. No apply the witness will decide in the witness box.
Thank you, witness. You are discharged.
Thank you so much, my lord.
All right. Any other witness?
Yes, my lord, subject to convenience. We have our audience.
Do you have any witnesses, or do you still have another witness, defendant counsel?
Yes, we have one more witness.
Is he available?
Yes, she's around.
Oh, okay. Yes, Abbas.
Yes, sir. Hi. Please sorry.
Their network is bad.
The second. Wow, now farm.
See, I can't see. Okay, I cannot. She a female?
Yeah.
Yeah?
Yes, sir.
I can't see that, Abbas. Is it a woman or a man?
Yes, my lord.
Eh?
My lord,
Hey, I can't see anything. Is she affirmed or she swore with the Bible or Quran? I don't know. Eh?
My lord.
Yes?
She was affirmed.
Okay, it's a lady. I can't see. I have to check what's Yes?
Yes.
Okay, I can now see.
My name is
What's your name, please?
Hogla.
If we can't hear, we have to adjourn this matter to another day. Maybe when we start early enough with them. If I can't hear you, I can't just say. Hogla,
my name was Hogla.
Yes. Yes, counsel.
Yes. Where do you work?
I'm a development under development sector.
Where do you work? Where do you work? Do you work with the defendant, Development Exchange Center?
Yes, sir.
Yes, counsel.
Yes. Do you remember giving your testimony before this formal court?
Yes, sir.
Dated the 24th day of March 2020.
Yes.
If you see the statement, how will you identify them?
I want to start from my name and
Yes, counsel.
Yes, my lord, they applied to say the wouldn't say statement.
Yes, show her.
Dated the 24th day of March 2025.
Yes, show her. Yes. Yes, counsel. Show her. That's your statement. Okay. Yes, counsel.
Yes. You want the court to accept this statement as evidence with you before this formal court?
yes, sir.
Yes, counsel. It's on record.
Yes, my lord, the witness have identified the same statement. We apply
Yes,
that it should
it's
be
on
accepted
record.
as the court pleases. Witness, in paragraph of your statement that was just adopted by the formal court, you
Paragraph
made mention
what?
of paragraph 7.
Okay, 7.
Yes, you made mention of a query letter dated the 5th of October 2020.
Yes.
And in paragraph 8, you make mention of an audit report marked as Exhibit C,
Yes.
dated the October 2028.
Yes, Council.
Yes, and in paragraph 9, you make mention of field internal auditor. He said that said report is dated 6th day of September 2018. 6 September,
Yes.
paragraph 9. And in paragraph 10, you make mention. Sorry, my lord.
Yes, you have referred that to paragraph 7, 8, and 9.
Yes, then in paragraph 10, you make mention of a demotion letter dated the of November 2018.
Yes.
Yes, and in paragraph 11,
Yes.
you make mention of it dated the 3rd of June 2014. 3rd day of June 2014.
That's
In
paragraph 11.
paragraph 11,
Paragraph what?
paragraph
14. Okay.
Sorry, my lord. Paragraph 14, because it was the organization policy. No, paragraph 14 exhibit dated the 9th day of October 2014, marked as exhibit H.
Yes.
Yes. And you make mention of an exhibit in paragraph 15.
Paragraph what?
Paragraph 15, exhibit I.
Exhibit I.
Exhibit I.
Yes.
Dated the 10th day of October.
Yes.
Yes. Then in paragraph 17.
Council, I don't know if the same document standard by the DW1.
No, DW1 didn't send that exhibit I. It was L.
Okay. Okay. All right. Yes. You didn't tender. Go ahead. Go ahead. Okay.
Then in exhibit J, you make mention of calculation dated the 7th day of July 2024.
Paragraph what?
Paragraph 17. That's exhibit J.
Exhibit J has no documents of July, please. There's no date of July there. Or is it paragraph 18 you refer to?
Paragraph 17 and 18.
Okay. You said it's 17. Yes.
18th, July 2020.
Yes.
Then in paragraph 19.
Yes.
Make mention of exhibit K. Sorry, my lord, let me check the exhibit.
Yes, paragraph 19 SVK, yes.
Yes. Dated is the same dated the 7th day of July 2024.
Yes. Yes, counsel.
These are the exhibits mentioned by W. If you see those documents, how will I identify them?
Identify it.
Be audible.
Yes, witness.
I will identify it as the president of the Development Exchange Center.
Yes.
Yes, my lord, may I apply to
Show
the
her those
witnesses
documents. Just
documents?
show her.
Yes,
Since
together
that
with
was
the
what you
certificate of
referred to in our
compliance,
witness statement, show her.
yes. My lord, may I show her the certificate document
Show her the
together with
documents.
certificate of compliance in line with section 8 of the evidence act because they are computer evidence.
Being the query of 28. Here with me. The report.
Please just look at those documents, browse through them and see if those are the documents, because he has listed all. You don't have to start referring me to them again. Look at them if those are the documents you want to rely upon, please. He has already mentioned all those documents. So look at them if those are the documents which you want to make use of at this trial.
Yes, my lord.
Yes, counsel.
Yes.
Yes, my lord, the witness have identified the said document.
Yes.
Apply that should be considered as an exhibit in respect of this matter. My lord, the documents are pleaded and annexed as an exhibit in our statement of defense. My lord, the witness reference a certificate in compliance with section 24 of the Evidence Act. The document being the computer generated evidence printed via mail. We are most grateful.
Yes, claimant's counsel.
Yes, my lord. My lord, we objected to the admissibility of this document, so we will reserve our argument at the final address, my lord.
So at this stage of trial, documents are deemed admissible in evidence and marked as follows. We have query of 5/10/2018, Exhibit B, audit report, Exhibit C, letter of 6th day of September 2018, Exhibit D, letter of 7th November 2018, Exhibit E, reports of 3rd June 2024, Exhibit F, letter of 9th October 2024, Exhibit H, memo, Exhibit I, audit reports of 9/8/2023, 26/8/2023, 24/5/2024, and email of 7th July 2024, Exhibit J, email correspondences, Exhibit K. Meanwhile, counsel are permitted to join issues in their final addresses regarding these documents as to their admissibility in evidence. The court shall, in the course of writing its judgment, determine the issues.
As a court, please.
All right. Yes, counsel.
Yes, my lord, on our own partners of forgiveness.
Claimant's counsel, please.
Yes, my lord. Witness, are you part of the auditors that investigated the matter at Zuru branch? Are you part of them?
Internal audit.
Are you part of
Are you
those?
part of those that investigated the matter at Zuru branch?
No, sir.
All right. Yes, counsel.
The entire investigation has to do with the calculation of money. Is that correct?
Yes, sir.
Yes, counsel.
There was never a time when the claimant was present to compare the document and make clarification. He was never given that opportunity. Is that correct?
He has given a monthly.
What I'm saying, there was never a time when throughout the investigation of this audit team, there was never a time when the claimant was invited to make clarifications in respect of any document or any figure or any calculation. There was never a time when he was given that opportunity.
They sent him to.
Understand my question. There was never a time when they invited him. Look at this figure, it's not correct. This one is.
Yes, witness, was there a time, if you know, tell the court that he was invited to make clarification regarding those figures or so, or the documents under which he was being investigated?
No, sir.
Yes, counsel.
Yes. You have been exchanging communication via mail with the claimant. Is that correct? Official communication via mail you have been exchanging, you personally, with the claimant. Is that correct?
I don't understand what.
There is official communication, you as an internal auditor, with the claimant.
Yes, sir.
Yes.
Yes, counsel.
Yes. I don't know which exhibit this one. Exhibit no, they didn't write it. Okay. There was never a time when you sit down with the claimant and make calculation that he is responsible to pay 10%. There was never a time when you reconcile figures with him before you send him a letter of suspension/demand.
It was done.
I'm talking of this particular case because he used to pay money, and the money is based on percentage. And there are some figures that you arrive at. So it is based on this that you pay so percent. There was never a time when the claimant was present to clarify that figure or to convince him that this is where we arrive at and this is what you have to pay the percentage. There was never a time when the claimant was given that opportunity.
He has the figure, soft copy. When the query was having him soft copy, the figures.
Was there, please let me get you clear. Was there a time that you reconciled figures with him before his suspension and or a time you reconciled figures with him for him to regarding before his suspension on the demand for 10% or so to be paid by him, 10% of whatever was agreed? Was there a time that there was any reconciliation of those figures done with the claimant before his suspension?
No, sir.
Yes, counsel.
That will be all for this witness.
Yes, defendant counsel.
Yes, my lord, we have no examination. Apply the witness, EW to be discharged from the witness box.
Do you have another witness?
No, my lord, would the EW to apply the case for
Is that the case for the defense?
Yes, that's the case for the defendant.
Thank you, witness. You are discharged, please. So, counsel, at this juncture, the court will direct parties are counsel to file final written addresses on behalf of the parties.
As the court pleases.
To file and exchange final written addresses, including reply on point of law where necessary.
As the court pleases.
So we'll give you a date. You have 21 days each, and reply on point of law 7 days. So that's 49 days. You are well guided by the rules of court.
Yes, my lord.
So the defendant, you file first and serve on the claimant, please.
Yes.
As soon as the claimant receives, the time of the claimant starts running from then, the 21 days.
As the court pleases.
So we'll give you a day, we'll suggest dates. Yes. 3rd of, okay. Yes, Counsel, check your diaries for 3rd of July.
3rd of July.
Yes.
Yes, yes.
Friday.
Yes.
It's Friday. It's convenient, my lord.
Convenient.
All right. I think that should be 10 o'clock. So they should all be connected.
My lord, it is Friday, my lord.
Yes, it's Friday. That's why I said for 10 o'clock. So we'll start early because of the network issue. Yes. So case is adjourned to 3rd day of July 2026 for adoption of final written addresses.
As the court pleases.
So counsel shall file an exchange same
As the court pleases.
before the next hearing date.
As the court pleases.
Abbas, call the next case.
So this one. NIC and that's 0 to 2025. It means the issue versus Kelly. My lord, the case.
Are the parties present?
The claimant is present, my lord.
Present in court?
Okay. Yes, my lord.
How about defendants?
Defendant absent.
Yes, appearance of counsel.
May it please my lord, Najib Haruna. My lord, my humble appearance is for the claimant.
Defendant counsel.
May it please be Lord Agnes Hechirika.
Please excuse me. This the public hearing, please, if I may put it that way. If you are not connected to this matter and you just want to be part of it, please just mute your system or device so that we don't have disruptions from this end, please. Yes, Chief Magnus.
Magnus
Ihejirika.
Yes, my lord. For the defendant.
Yes, counsel.
Yes, my lord, this matter is slated to today for hearing, and subject to my lord's convenience, we are ready.
Yes, is the witness available?
Yes, my lord, the witness is available.
Okay, yes, Abbas.
My lord, our witness is a male adult Muslim.
Okay.
And he will testify in English.
All right, thank you.
I do strongly affirm that all the evidence I should give in this case shall be the truth. The whole nothing but the truth. So, my lord, the witness was on my lord.
Yes, it's on record, please. Let's proceed, please.
Sir, can you put your name to the hearing of the court?
My name is Said.
Where do you live?
I live in Benin.
What do you do for a living?
I'm a lecturer in technique.
Sir, can you remember giving a written witness deposition on the 2nd day of December 2025 to this honorable court?
Yes.
If you see that statement, can you identify?
Yes.
When was that? What date?
On the 2nd of December 2025.
2nd of when?
December.
What year?
2025.
Hold on, let's check what we have here. Yes, Rashina, please come over. I have to check if there was an amendment. Second December, you said?
Yes, my lord, 2025.
Oh, okay. The amendment. Okay. Just a moment, please. I think. Counsel, this you have an application. There's a motion. Have we taken that motion?
Yes, my lord, we've taken the motion.
It has been taken?
Yes, my lord. We took the motion before we took the PO on the I can't remember the date. Let me check. Hold on. That was December.
Okay, I think we took that.
Yes, my
that
lord.
was on the 8th of December 2025.
Yes, my lord. Yes, my lord. That is it.
Yes, before the PO. Okay. Yes, defendant counsel, do you intend to file do any consequential amendments?
You know, the police is virtually the same thing with the earlier one.
Okay.
Yes,
Yes, claimant's counsel, please proceed in the circumstance.
As the court pleases. Witness said identify your witness on oath. How can you?
I can identify it by my signature.
Okay.
And my picture.
Okay, kindly take a look at this, whether it is the one you are referring to.
Yes.
Well, having identified your witness statement on oath, do you want to adopt it as your evidence in?
Yes.
Hello, the witness has identified statement on oath, and we apply that same be adopted. Examination in chief.
Yes, it's on record.
As the court pleases. Witness, paragraph 5 of your witness statement, you made mention of condition of the first defendant. If you see that condition of service, can you identify it?
Yes, I can identify it.
How can you identify it?
The name of the institution is written on it and the logo of the institution. So I can identify it by the name of the institution and the logo of the institution.
As the court. In of your statement, you mention of letter of appointment dated 3rd February 2020. If you see that, you identify.
Yes, I can identify it.
How can you?
So it was addressed to me.
Yes.
Of your deposition, you also mention of a letter of confirmation of
paragraph what, please?
Paragraph 7.
Okay, all right.
You made mention of a letter of confirmation dated this of April 20. Can you also letter?
Yes, I can identify.
Yes.
In paragraph 10 of your deposition, you also of a letter of appointment as nodal office on 16th of April, dated 15th of April 25. Can you also
paragraph what? Paragraph what?
14, my lord.
Okay, yes.
Yes, I can identify.
Yes.
Also in paragraph 17, you made mention of a letter of invitation dated 2nd of April 2025. You also identified the letter.
Yes, I can also identify it.
Paragraph what?
17, my.
Okay, 17.
Yes, that's a letter
okay.
Invitation to
yes.
appear in the appointment and promotion and disciplinary committee. Then you made mention of warning you 24th day of April 2025. Can you also identify that letter?
Also identify it.
Yes.
Paragraph 23 also, you made mention a letter of suspension and downgrade of level dated on 25. Can you
paragraph what, please?
23.
Okay, 23.
Yes.
I can also.
Yes.
In 34, you made mention of your payslip. Can you also identify your payslip?
I can also identify it.
Paragraph what?
Paragraph 4.
34.
Yes, my lord.
Okay. Yes.
Kindly take a look at this document and tell this court whether you can identify them before the court.
Yes, letter of appointment, yes. Letter of conversion, confirmation of appointment, suspensions and downgrading. Yes. Letter written to me. Warning letter. Invitation to appear before the appointment and promotion. Yes, it is. These are all the letter, the one I presented and the one addressed to me by the institution.
Yes, Council.
Lord, we are these documents evidence. The documents were marked as contained and also given to the registry for marked.
Yes, we'll take them. They are marked already there. Okay, they are marked here. Okay, yes.
My Lord.
So we'll take them. Okay, yes.
Yes.
Yes, let's show the, yes, Claimant Council, you want to tender these documents?
Yes, my Lord.
My Lord, we have seen the documents we are objecting, but we reserve our objection to address stage.
You are objecting to all?
Yes, my Lord.
All right.
My Lord, before the documents could be marked, could we apply to leave the original documents and substitute them with a photocopy, my Lord?
Because I'm not here to look at them, so I would grant that prayer, but then the court registrar must look at them, the photocopy and the original, before he releases the originals to you.
As the court please.
Yes, so Abbas.
The most grateful.
Abbas, you have to see that the photocopy, aligns with the original content of the photocopy, that they are the same. It's just that one is original. And I only grant that prayer because so this issue of having exhibits missing, I wouldn't want this court to experience that.
As the court pleases.
Yes, so Abbas, you look at them carefully while let's put you on record. So then the documents at this stage of trial will be deemed admissible and taken in evidence, while counsel in their final addresses will join issues regarding same, and the court in the course of judgment will deal with those issues.
As the court.
So I'll just have those documents. We'll refer to the respective markings on those documents.
As the court pleases.
So counsel, we'll do that together, Najib. So just a moment, because I have my own records here, so that we'll be on the same page.
As the court pleases.
So, counsel,
my Lord,
can we start, please? So we'll take them one after the other, so that we'll be on the same page. You started with paragraph 5, 6, 7, and so on. So
yes,
let's start with that paragraph 5. What document is that, so that we mark them accordingly?
My Lord, that's of the defendant.
Sorry?
Condition of defendant, my Lord.
That's the one in paragraph 5?
Yes, my Lord.
Is that of the statement of fact, or?
Okay. What, my Lord, on statement of facts, it was marked B. That's
marked where? What? In the statement of fact, it's marked as well, because that's why I have you mark all these things.
Yes, my Lord. It is exhibit.
That's what in the statement of facts.
Yes, in the statement of fact, it is in paragraph marked as exhibit B.
Exhibit what?
Exhibit E.
E.
B for ball, my lord.
B.
B.
Conditions of service. Okay, so let's see. Conditions of service. Exhibit B. Yes, the next one.
Well, my lord, then
you mentioned one in paragraph 6 of the written statement on oath. So where is that in? That's what you refer the first defendant since the 3rd of. You refer to is it a letter of appointment of 3rd February 2020? Because you didn't mark this thing in the written statement or note. That's why we're having this difficulty. So I'm not supposed to be looking for this in the statement of facts. So you should tell me where they are in this. So I refer to it and use the marking there.
Okay, my lord. Sorry for that, my lord. It is in the statement of material facts marked serially.
Yes.
My lord, in number 1 on the material facts marked as Exhibit A is provisional offer of appointment as teaching staff.
Where is the document? You said condition of service. Because I don't want you to distort my records. You started referring counsel witness to paragraph 5. That paragraph 5 is condition of service. That's Exhibit B. So paragraph 6. What is in paragraph 6 and where is it in the statement of fact? What exhibit? That's what I want you to tell me.
Okay, my lord. Let me go back to
paragraph 6 of your written statement, witness statement on oath.
Yes, my lord.
What's the document referred to there?
That's letter of appointment, my lord.
So is that letter of appointment in your material facts? It's exhibit what?
It's exhibit A, my lord.
All right. Yes, next. You refer to paragraph 7.
Yes, my lord. In paragraph 7, we have the letter of conversion, my lord.
Letter of conversion, yes.
Yes, my lord, marked as exhibit A2.
Exhibit what?
A2, my lord.
Okay, A2. Yes. Is it just A2 and A3 or just A2?
A2, my lord. Then we have letter of confirmation still on
yes.
In the same paragraph.
Yes. Exhibit what?
A3, my lord.
A3. Yes, next.
Then on paragraph 14, my lord.
Yes.
We have a letter of appointment as assistant nodal officer.
Yes. Dated when?
Dated the 16th of April 2025.
Yes. So exhibit what?
My lord, it was marked as exhibit C.
Exhibit C. Okay, yes.
C, my lord.
Yes, next.
Then, my
paragraph
lord,
17.
Paragraph 17.
17, yes.
My lord, we have a letter of invitation to appear before APD and C, dated 22nd of April 2025.
Yes.
My lord, it is marked as exhibit T.
Exhibit D. Okay.
Yes, my lord.
Yes, next.
Then
paragraph 19.
Yes, letter of warning, my lord.
Yes.
And it is marked as Exhibit E, my lord.
Exhibit E. Yes. Next.
Then paragraph 23, my lord.
23. Yes.
Yes. Letter of suspension and downgrading, marked as Exhibit F.
Yes, Council. Exhibit F.
Then paragraph 34, my lord.
Yes, 34.
Payslip, marked as Exhibit G.
Yes, would that be all?
Yes, my lord.
Okay.
Letter of compulsion.
You mention it.
My lord, that.
All right. So I earlier on stated that council will be allowed in their final written addresses to join issues as to whether these documents are admissible or not. But at this stage of trial, the court will deem them admissible in evidence. And at the stage of writing judgment, I will deal with the issues as argued by counsel. So meanwhile, the documents are deemed admissible in evidence are marked as follows. We have condition of service, Exhibit B, letter of appointment. What's the letter of appointment? Is it Exhibit A now? Because I didn't get that.
Yes, my lord.
That is it Exhibit A?
Yes, my lord.
Please confirm. Okay.
Letter of appointment is Exhibit A, my lord.
All right. Letter of appointment, Exhibit A. Letter of conversion, Exhibit A2. Letter of confirmation, Exhibit A3. Letter of 16th April 2025, Exhibit C. Letter of invitation, 22/4/2025 to appear on 23/4/2025, Exhibit D. Warning letter, Exhibit E. Suspension letter and downgrading, Exhibit F. Then pay slips, Exhibit G. They are all admitted in evidence.
I've got please, my lord. I just noticed there is Exhibit A1 to notification of appointment.
A1. Let's see that
Yes,
if it's contained in your. Yes, there's a letter of 1st January 2022.
Yes, my lord.
Notification letter / notification of employment, Exhibit A1.
Yes, my lord.
Magnus, I hope you are on the same page.
Yes, my lord.
All right. Notification of employment. So that's Exhibit A1. So they are all 10. Yes, sir, Counsel.
Yes, my lord. We also gave the defendants, my lord, a notice to produce some letters in paragraph. That is in the statement of facts, my lord.
Yes.
Statement of facts. In paragraph 15.
Yes. Yes, Council.
Yes, my lord. And paragraph 19. Paragraph 15. Paragraph 19.
Yes.
The paragraph 15. 15, 19.
Yes, Council.
Sorry, my lord, there is one other paragraph that I did not.
Okay.
One. And paragraph 21, my lord.
Yes.
So, my lord, I don't know whether the defendants are with the letters.
Yes, Chief Magnus.
Yes, my lord. I had thought that they would have informed us that this is the particular date they need the document. Or otherwise, we tender the document through our witnesses.
Yeah, but you are aware that the matter is coming up today, and since this thing was filed since when? It was filed since served on you since.
The defendant to tender.
Sorry?
I said it requires an officer of the defendants to tender the documents. We are hoping that it is when we enter our defense.
All right, so whichever way, but they've given him notice to produce. So if you want to tender it when the defendant is fielded as a witness, so I think that is still. Yes, you heard him, Najib.
Yes, my lord. My lord, in the absence of the documents produced by the defendant, we have the secondary evidence, my lord, which we apply to tender. Expected they will bring the original today because they were in their custody. So we have the secondary evidence.
Yes, Najib.
Yes, my
yes,
lord,
the defendant can serve you've been given notice to produce, and even the evidence act permits where you fail to produce those documents, you can rely on the secondary evidence with him. You've been given notice to produce those documents.
Stop, please. That's the position of the law.
Yes. So. Yes, Counsel Najib.
Yes, my lord. The circumstances we apply to tender the documents. Secondary
Which
evidence.
document? So you have to refer the court. You have referred us to the paragraphs.
Yes,
so
my
we'll
lord.
go back again. That's paragraph 15.
Yes, my lord. It is a letter.
Yes.
Of appointment dated 17th April 2025. It is captioned response to appointment as assistant nodal officer.
Yes, Counsel. That was yes. Go ahead. So we'll mark them accordingly.
Yes, my lord. Then in paragraph 19 of the statement of facts, there is also a letter declining the appointment dated the 24th of April 2025. Caption letter of decline appointment as assistant nodal officer.
Yes.
Then my name, paragraph 21 of the statement of material facts is a letter of appeal.
Yes.
Dated 5th of May 2025.
Yes. There are 3 documents.
My lord?
There are 3 documents.
Yes, my lord. 3 documents.
Yes, Council. So we'll, I think we stopped at exhibit what now?
G.
Exhibit G. Yes, Magnus. Yes, he has raised to tell. Are you objecting to any?
Yes, my lord.
Stay in your final address.
My lord.
What do you have to say regarding the document? Because they are in your custody, the origin, and they gave you notice to produce.
Said no objection to the admissibility
all
of the
right,
document.
okay. All right, okay. Yes, so the documents are admitted in evidence and they are marked as follows. We have a letter of 17/4/2025 as per paragraph 15 of the statement of material facts. It's marked as Exhibit H. Then the next one is letter of 25th April 2025 as per paragraph 19 of statement of material facts, Exhibit I. And lastly is letter of 5th day of May 2025 as per paragraph 21 of statement of material fact, Exhibit J. They are all admitted in evidence.
As court pleases. Thank you, my lord.
So, Abbas.
Yes, my lord.
Yeah, I hope you are with those documents.
Yes, my lord.
Yes, so you mark them there accordingly. Then the initial ones that were admitted in evidence, you look at them, the photocopies and the originals, so that you can release the originals to claimant's counsel. Yes. Yes, counsel.
Yes, my lord. Upon receipt of the statement, joint statement of defense of the defendants, my lord, we find claimants replied defendants' joint statement of defense.
The claimant filed what?
Claimants replied to the defendant's joint statement of defense.
Yes.
The witness might not give an additional witness statement on oath. With the kind permission of my lord, I want to lead him to adopt.
When was it filed?
It was filed on 6th of August 2025.
Please come and look for this thing. We don't sit down. Since the court to look for this thing. Come and look for the reply to the statement of defense. Where is it? They didn't send it to us. He said it was filed on the 6th August. Yes, counsel.
Yes, my lord. We apply that be given permission to allow.
Yes, go ahead. Refer him to that statement. Yes.
As the court pleases, my lord. Witness, can you remember that on the 6th day of August 2025, you gave an additional statement on oath before this honorable court?
Yes, sir.
See that statement. How can you identify it?
I can identify it through my picture and signature.
Can you take a look at it, whether it is the statement you are referring to?
Yes, it is. It is the statement.
It is additional statement on oath. Do you want the court to take the evidence in this case?
Yes.
Adopted his taken additional statement on oath as his evidence before this honorable court, my lord.
Yes, counsel.
That is all for him. In examination, my lord. Thank you. We are much obliged.
Can we really do any process animation? Yes, Chief Magnus.
Yes, my lord.
Let's see how, if we can really, how far we can go with this process examination. Ordinarily, I would have adjourned, but let's see how far we can go. The day is fast spent, and I hope the network will be friendly. Yes, let's start.
Are you aware that condition of service of the first defendant is governed by 2021 condition of service and not 2013? Are you aware?
Not aware.
You say it's that of 2021 and not 2013?
2021 and not 2013.
Okay. Yes, witness?
I'm not aware.
Okay. He said he's not aware.
Stop this.
Yes.
You said Savicom is a federal government policy that requires compliance. Am I
right? Chief Magnus, what's the question?
I said Savicom because that is the genesis of his problem with the defendants.
Yes, Savicom is what?
It's a federal government that requires compliance.
That Savicom requires what?
Compliance.
Okay, all right. Yes, witness.
Yes, through the appropriate office in the institution.
Through
because
the appropriate office.
Yeah.
Please repeat.
It should be through the registry.
Yes, I would like to have that again.
Through the appropriate office. That is, it should be through the registry, not elected.
Through the registry.
Yes, sir. Yes, sir. Yes, ma'am.
My lord.
Yes, my lord. Yes, my lord.
Yes, counsel.
Okay. Did you sue the federal government for implementing Savicom policy?
No.
You're asking if he sued the federal government?
Yes, for initiating Savicom.
Okay. He said no. Yes.
The defendants have the right to post, promote, demote, and discipline the staff. Am I right?
Yes. But according to the law.
Yes, counsel.
With your appointment as assistant nodal officer, you are still a lecturer, am I right? You are still a lecturer, am I right?
Yes, sir.
With what?
His appointment as assistant nodal officer. He is still
assistant nodal officer.
Yes, sir. Yes, my lord.
Okay.
He is still an academic staff.
All right. Yes.
Sorry. You are mandated to attend. Am I right?
He's what?
Mandated to appear before a disciplinary committee, and he said yes.
Okay. Yes.
You appeared and made your representation, your grievances. Am I right?
I appear and I say to them that I reject.
You explain your own side of the problem.
Yes.
You appeared and what?
And explain his own side of the story.
Okay. Yes.
The suspension was made to the outcome of the committee. Am I right?
No.
So what happened? Tell us now.
He said no. Yes.
Tell us now.
Yes, witness.
So my question is, if it is not, then on what basis were you suspended?
Okay. I was suspended due to the fact that I did not accept the appointment. And the appointment came after a congress, our ASU congress, we attended in the institution. Where I chose
yes
my own disagreement. Where I chose
Sorry,
my
sorry, sir. Let us take it
agreement.
one by one. I said your suspension was based on the outcome of the disciplinary committee. That's my question. Your suspension was based on the outcome of the disciplinary committee. Yes. The suspension was based on the disciplinary committee.
Yes, it's based on the outcome of the disciplinary committee.
Was based on
yes.
The normal working hours of government establishment is between 8 o'clock to 4 o'clock. Am I right? Normal civil service period between 8 and 4 p.m. Am I right? Government establishment 4 p.m. Am I right? It's the question, sir. It's a question, sir.
Okay.
The normal office hour for civil service is between 8 in the morning and 4 in the evening, 4 o'clock in the evening, 4 p.m. Yes or no?
Yes.
Yes. Yes, Council.
The issue of minimum of 12 hours and maximum of 18 hours per week, as contemplated by you.
Minimum of what?
The
minimum of what?
12 hours.
Okay.
And maximum of 18 hours per week.
Okay.
Yes, my Lord.
Yes.
It's for lecturing in the classroom. Am I right?
Yes, witness.
Yes, my Lord.
Yes, is that the position?
It's written in the condition.
I asked you a question. Answer my question. Whether it's written there or not.
Are you saying yes, as written in the condition of service?
Work. Am I right?
He said the issue of minimum of 12 hours and maximum of 18 hours per week is for lecturing in the classroom.
He said yes.
Yes. It's written in the condition. My Lord.
What's your response?
Yes, ma.
All right.
Yes, my Lord.
Yes, Council.
Oh, my Lord. Okay. From being a librarian, you were converted to an academic staff. Am I right?
Yes.
From being a librarian?
Yes, he was converted to an academic staff.
Okay. Yes. Yes, Council.
That all the members of the Academic Staff Union of Polytechnic were against SAGCOM policy.
Do I have
anything to show this court that all the members of Academic Staff Union of Polytechnic, ASU?
Yes, I have. A letter was.
If there is, show this court.
Yes, I have. A letter was written by the ASU of the institution, the Academic Staff Union.
Sorry, sir. Sorry, sir. Listen, before you answer question, you have to understand the question.
Okay.
Do you have anything to show this court? To show this court, if there is, present it now and not telling us a story. If you have it here, you tell us that you have it here and you present it. If not, you say tell the court that you don't have. You understand?
My lord.
Now, do you have anything to show this court now that all the members of academic staff union of the Polytechnic are against Sabicom policy?
Yes, witness. Do you have anything before the court or now with you to show the court that all members of Haastrup were against the Sabicom policy? Yes, witness. Please bring this thing up. Let me see if it's still on. It should be from there. Just raise this thing up with us. Okay, it's okay. So it's from there. Yes, witness. It's called Sokoto. I'm finding it. It's from there. That's why I say I'm not sure if we can really. Yes, witness. It's from Sokoto. We have to adjourn. Yes, Chief Magnus, are you still online? It's from there. Once they connect now, let's just look for the next date for me for Sokoto, except if it's already afternoon, maybe that's. Yes, Chief Magnus. So if they can't get connected, you now call Abbas to tell them that these are the dates we have. Is it for Sokoto? Yes. Okay. They are all Sokoto matters. So tell him that in the next 10 minutes, if we cannot get connected, that we are adjourning to 3rd July. Go and tell him now. So once it's 10 minutes, we just. Yes, Najib. It's from their end. Hey, officer, give this to Dayo. We didn't use this one. Then we have to adjourn. Let her come. Exactly. They tried 1 o'clock and we did. We completed that defense. Yes, Chief Magnus. We have to adjourn. You have told him? They can't. You have told him that it's adjourned to 3rd July. That's what I said now. I said tell him that 3rd July, that because we cannot reach no network again. No, tell him while I wait for 10 minutes, then we'll take it that it is adjourned. It's from their end, it's not from here. Is it network from their end or from here? Have you told him? So call the dial. You just give them 5 more minutes. That I should tell counsel, eh? Okay. It's off. Yeah, I think they are using the network in the court there. This is their own device. So come and pack this thing. Pack away. No, after that, we and check network. Then they tissue. After that. So let's take it for 3rd July. Eh? Mm-hmm. So please make sure you tell the Abbas that the court has already adjourned because of the network. Where is Dayo now? Ṣebí mo ní kó padà wá. Who asked him to wait at the door? Is the officer not here? Oh, okay.